Hello students, so today I'm going to teach writs. In India, the power to issue a writ is given to the Supreme Court under Article 32(2) and to the High Court under Article 226. However, the High Court have a broader power in this regards. This is because there is an insert of other purposes in this section, and the High Court can issue writs for enforcement of all rights granted to the citizen, but the Supreme Court can issue writs for enforcement of only the fundamental rights granted to the citizens. So the Supreme Court and the High Court have the power to issue five kind of writs, and these are first one is the habeas corpus. So habeas corpus is in the Latin term, which means to have the body, and this writ is issued to relieve a person from any unlawful detention. So if a person is detained illegally and it is against his consent, then he can file an application in the Supreme Court or the High Court for habeas corpus. In Rudul Shah versus State of Bihar, it added a new dimension to judicial activism and raised a set of vital questions such as liability of state to compensate for unlawful detention, feasibility of claiming compensation from the state under Article 32 for wrongful deprivation of fundamental rights, propriety of Supreme Court passing an order for compensation on an habeas corpus petition for enforcing the right to personal liberty. Now, mandamus. So, the Latin term mandamus means we command. The writ is issued in the form of a command given by the judiciary, which directs a constitutional, statutory, or non statutory body to perform a public duty. So, which is imposed upon it by the law. So this is for the commands that are given by the judiciary with the directions of constitutional, statutory or non-statutory body to perform a certain kind of public duty that is imposed by the law. So this is for that. Commanding is the part of it. So this means that's why this is called to be command. So it is can also be issued by a superior court commanding an inferior court to perform its duties. And this writ is also issued to prevent the authority from doing a particular act which it should not, and it is not legally entitled to do. The writ of mandamus cannot be issued against a private individual who is not legally required to perform the public duty. Um, so, for example, if A is a police officer who is not performing his duty of registering a complaint brought to him by B, the court can issue the writ of mandamus, compelling him to register it. However, if A is not obliged by law to perform a duty, then the writ cannot be issued against him. Now, the writ of mandamus is issued on the following grounds. So, if the petitioner has a legal right, the legal right of the petitioner has been infringed, and the legal right has been infringed because of the non-performance of any legally required duty by a public authority or a private individual who is acting under the public authority, and the petitioner has demanded the performance of the duty, but the public authority has refused to perform it. So the rule of locus standi in this is it is strictly followed in while issuing writ of mandamus. The petitioner has to prove that he has a right to enforce public duty in his favor, and the mandamus is neither a writ of course nor a writ of right, but that it will be granted if the duty is in nature of public duty and it especially affects the right of an individual provided there is no more appropriate remedy. Now the courts are unwilling to issue writ of mandamus against high dignitaries like the president and the governors. And in case of SP Gupta versus Union of India, judges were of the view that a writ cannot be issued against President of India for fixing the number of judges in High Court and filling vacancies. So in C.G. Govindan versus State of Gujarat, it was refused by the court to issue the writ of mandamus against the governor to approve the fixation of salaries of the court staff by the Chief Justice of High Court under Article 229. Hence, it is submitted that the governor or the president means the state or the union, and therefore issuance of mandamus cannot take place in such a circumstance. Now, certiorari. So, the Latin expression of certiorari means to certify, and it is issued in the form of a command by a superior court ordering an inferior court or any other inferior quasi-judicial body to transmit the records of a proceeding pending before it to the Supreme Court. So, the records of proceedings are called upon by the Supreme Superior Court, and this is usually done in the following circumstances. So, when a superior court believes that the inferior court does not have jurisdiction to decide the matter, or when the inferior court violates the principle of natural justice while deciding the matter, or when the inferior court decides on a matter procured by fraud, or when the lower court makes a wrong decision because of an error of law which is apparent on the face of the record. This means that if the inferior court makes a decision based on a clear disregard of statutory provision, then the superior court can issue the writ of certiorari. However, if the decision is made because of errors in facts, then the writ is not applicable. For example, High Court believes that the district court, which heads a case, did not have monetary jurisdiction to decide upon the matter, and yet it did, and it has taken up the matter. So the High Court can issue the writs and quash the district court's order. Now, prohibition. So, prohibition means to forbid. So, this writ is also known as to stay order. So, it is issued by the superior court to prevent an inferior or a quasi judicial body from continuing its proceeding. So, it is issued in circumstances such as when inferior court or quasi-judicial body does not have jurisdiction to hear the case, or when inferior or quasi-judicial body violates the principle of natural justice, or when the inferior court or the quasi-judicial body is not acting according to the provisions of the law. So the basic purpose is to secure that the jurisdiction of an inferior court or tribunal is properly exercised, and that it does not assert the jurisdiction which it does not possess. Thus, writ of prohibition is available during the pendency of the proceeding and before the order is made. Now, prohibition is a writ of preventive nature. The principle of this is prevention is better than cure. Now, quo warranto. This is the fifth writ, which means by what authority. So, in this, the writ restrains a person from acting in an offence when he is not entitled to and has wrongfully usurped the position. The basic fundamental purpose of this writ is to ensure that an unlawful claimant does not take over a public office, as this can harm the public and takes away opportunities from those people who actually deserve to take over that office. So, in the matters involving the writ of quo warranto, anybody can file the petition, even if the person who is filing the petition has not been personally aggrieved. When the writ of quo warranto is issued, certain essentials are to be fulfilled, which are that the office has been wrongfully assumed in a public office and not a private one. The public office has been created either by the statutory provision or the constitution. The office is of a permanent nature and is not made for temporary term. The person against whom the writ is to be issued is in possession of the office, and the person against whom writ is to be issued is one who has been disqualified from a public office, yet he is continuing to possess it. Thus, if A is a person who is not qualified and has illegally taken possession of an office of a police officer, the court can issue the writ of quo warranto and challenge this possession. However, it must be observed that the court has complete discretion in issuing this writ. Thus, if the court feels that issuing of this writ would not be beneficial, it has the discretion to not issue it. This can be understood with the help of this case. Thank you.